Good evening, everybody, and welcome to the second calling in meeting today of the Customer and Corporate Services and Scrutiny Management Committee. It's nice to see you all again. There is a certain sense of deja vu. Just quick bits of housekeeping. If you've got your mobile phones with you, please make sure they're turned off or on silent. I think everybody in the room knows where the toilets are, and we're not expecting fire alarms, so if it goes off, it is for real. In terms of apologies, again, there's a few changes to the committee, so I'll just go through them quickly. Councillor Hollier is being substituted by Councillor Daubney. Councillor Fenton is being substituted by Councillor Hook. Councillor Orrell is being substituted by Councillor Bassey. Councillor Pearson is being substituted by Councillor Wan, and Councillor Rowley has given his apologies. On to the main agenda items then. Are there any declarations of interest? No, not seeing any. Agenda item 2 is public participation. We don't have anybody registered for public participation, so we can move on to the substantive item, which is agenda item 3, which is the called in item, the review of controlling the concentration of houses in multiple occupation, Supplementary Planning Document 2012, brackets revised 2014, in response to the Council motion of December 2021. So I'll just set out briefly how this evening's meeting will run for this section. So as I explained this afternoon, we're still operating on the constitution, which will be superseded at annual council, but we're still operating according to the existing constitution. So the way that the meeting will work is I'll invite the calling in members to come to the table and to present their case. They've been told that they can have 3 minutes each to address the committee, and there'll then be the opportunity for members to ask them questions. Once that section is finished, I'll then invite the executive members to come to the table and do the same thing. I'll give them each 3 minutes to address the committee, and then invite members to ask any questions. At that point and throughout those two sections, I'll ask Neil Ferris as the officer responsible just to be kind of making a note of any questions or technical things that might come up. I'll then ask Neil to address any of those questions that have come up during those two sections and answer any further questions that committee members may have. And then the committee can debate anything that we've heard before deciding how we wish to deal with any proposals that may subsequently come. So I will get straight into business and invite Councillor Waters and Councillor Pavlovic to come to the table. I'm just going to make a note that Councillor Pavlovic was a late signatory to the call-in. So we've double checked and cleared that that's perfectly fine for us to do that. So he's an additional signatory and is here to present a case. So I don't know which order you wish to do. It's entirely up to you. Councillor Waters, I think Councillor Pavlovic's up for you to kick things off. So if you could address the committee about 3 minutes, and then Councillor Pavlovic to follow.
Thank you, Chair. This call-in agenda rightly highlights the executive decision in relation to the December 16th council motion, but in reproducing the executive agenda of the 21st of April, perpetuates the mistake I pointed out at that executive meeting. Annex B, which is on your page 7, refers in paragraph 1 to executive being asked to consider a review of the HMO supplementary planning document. That's not correct. The Labour amendment to the motion I put forward tightened the wording up. Council requested executive initiates without delay a review. So leaving aside the 4-month delay of initiating something supposedly without delay, the decision executive were boxed into by the corporate director was to ignore clear instruction from council and mislead themselves and therefore the local plan inspectors that the current policies dealing with HMOs are robust when they have clearly not been fit for purpose for some years now. Option 2 was approved at executive is a fairy story. Does this committee believe in fairies? Option 1, as presented by the corporate director, explains the difference to you of policy in the draft local plan, i.e. development plan document, as opposed to a supplementary plan document, rather overlooking the uncomfortable fact that it was actually the supplementary plan document that came first, and policy H8 was simply copied from that into the plan. Leaving that aside, paragraphs 41 and 42 mention a post-adoption review of the local plan of policy H8. Very misleading to all concerned, as a review of a just approved, in the unlikely event of that happening, local plan won't happen, as policy reviews usually only take place after 5 years. The policy in the local plan and the supplementary planning document have been shown to be not fit for purpose for years, and most worryingly, hopelessly out of date with current circumstances. Clearly, the unrestrained expansion of student numbers at York University is distorting the local housing market, and taking account of the huge expansion of purpose-built off-campus student flats, it's long overdue that policy H8 reflected that with a reduction in percentage thresholds. The supplementary planning document there to support the implementation of policy H8, of course, should be reviewed to take into account best practice from other local authorities. A useful table in the links in the correspondence I presented you all with. Of course, policy H8 and the supplementary planning document need reviewing. I've been asking since 2015. So any potential impacts on the local plan are entirely the fault of the relevant members and officers. The student accommodation issue is one of the key drivers in population growth and housing need in York, and is distorting greatly the housing market in terms of housing affordability and availability for York residents. This issue needs to be got right and not kicked into the long grass for another decade. And any review needs to encompass the Airbnb situation and permitted development rights on HMOs as well. As a committee, you can insist to executive that this matter is considered properly and that the council should act in the interest of York council taxpaying residents, or failing that, I'll simply go to the July or September local plan sessions and challenge the soundness of this aspect of the local plan. I've already written to the inspectors and will further update them after today's meeting. Thank you, Chair.
Thank you, Councillor Waters. So I'll go to Councillor Pavlovic next, and then once he's said his opening remarks, I'll invite questions from members.
Thanks. And thank you for the time to speak to you. And my premise is really quite straightforward as to why this should be returned to executive for further consideration. When the report was presented to executive, it included two options. The first option was so apocalyptic in its terms that no one could have supported it. To ask them to suspend the current local plan examination process, whilst the strategic planning team consider whether policy H8 would be a main consideration, and subsequently that this be a withdrawal of the plan, is frankly a ridiculous proposition. The draft local plan runs to 315 pages. Policy H8 is 3 bullet points with 6 paragraphs of explanation. No one in their right mind would consider that to be a main consideration that would require the withdrawal of the plan. It's accepted in the report that the HMO SPD is already only in draft form, that it only carries moderate weight as it is, and that an inspectorate appeal decision only last week gave it so little weight that they felt able to allow an appeal for an HMO in a street in which the threshold had already been breached. Therefore, there is absolutely no reason why, should this be returned to executive, that an option couldn't be included which allows for the evidence base to be investigated as to whether a revision of policy H8 is required. This could be undertaken whilst the local plan examination was ongoing, and if so, then consulted on later. The local plan itself may well be absorbing the current resourcing of the strategic planning team, as indicated at paragraph 31, but that's a separate issue and is not one that was given to executive as why they should not agree to a review process for the draft HMO SPD. I am sorry to say that despite this being a significant issue for many residents, that this administration appears not to really care about HMO densities in this city. As it also says, HMOs will be also considered a low priority for planning enforcement. At least there should be some honesty and say you don't have the resources or the will to enforce breaches of HMOs, so I'm not going to do anything about density breaches, rather than a fig leaf of doing so jeopardizes the local plan. The decision sheet from executive found that 1, confirm that the current HMO policies are evidence-based, robust and fit for purpose. I would argue that the current HMO policies are anything but fit for purpose. The appalling failure to complete enforcement of breaches of HMOs is nothing short of a disgrace and is letting down those residents who report them. I have at least 7 outstanding enforcement cases of unauthorised change of use to a HMO, some going back to 2018 and most now over 2 years old. I inquired in 2017 as to the number of HMOs in Hull Road Ward and got a figure back of 749. In 2021, that same question showed 850. Houses are being turned into HMOs and nothing is being done to stop this by planning enforcement in clear breach of the Article 4. If that's a robust HMO policy, we have a very different interpretation of robust. To conclude, the options presented to Executive were not reasonable and should have been more balanced and actually given them some viable options other than a choice of everything is fine as it is or withdraw the local plan. Thank you, Chair.
Thank you very much, Councillor Pavlovic. So I'll now invite members to ask any questions that they may have. Councillor Daubney.
Thank you very much, Chair. To the signatories, would you suggest going against the officer of advice and effectively withdrawing the local plan? Thank you, Chair.
I've just argued, if you listen to the report that I gave, that that's a false proposition. They can be run alongside each other. All you're asking for, and what the motion to council was, that an investigation be done, and that's a review of the existing HMO SPD. So it's not saying implement it, it's saying do the investigation, see if the thresholds are, the current thresholds are appropriate. If they're not, then it can go out to consultation and reconsideration at a later time. It does not require a withdrawal of the local plan examination process.
Chair, if I could briefly answer that with a question, would you prefer if the local plan went forward with a policy that is clearly unsound and failed on that basis?
Councillor Norman, I'll bring you in 1 second. I guess the question that I would just ask on the back of that, which I think sort of maybe helps us to understand how we've got to this position, because I am a little bit confused. My understanding of when you submit a council motion is that they're sent through to CMT and advice about whether or not it's actually deliverable is then given, and amendments are sought at times. You know, for example, if we said, oh, you know, we want to put an extension on York Minster, and they said, oh, well, actually, that's not feasible for these reasons, you're advised to change it. And I'm just wondering if what you appear to be saying to us is that the outcome of the motion was to present something which would be catastrophic for the executive to support. Was that sort of advice given to you in advance of the motion being put forward?
No. There was no advice whatsoever on those grounds, and the motion itself, because there was subsequently a Labour amendment submitted, had quite a deal of correspondence prior to it going to full council, at which point, if there were concerns flagged up from corporate management team, they could have been flagged up. There's plenty of opportunity. I would suggest, and again, it's just supposition on my part, that everybody thought they want to open hell of that motion getting passed. But because of a unique set of circumstances, when one of the voting members was absent and the casting vote of the chair couldn't be made because of his prejudicial interest in managing HMOs, it did get passed, much to various people's consternation.
Well, I think actually the point I would just make is that it was passed unanimously, in fact. There was an amendment that was put forward and that fell. Yeah, I went back and checked the voting record ahead of the meeting. So an amendment was put forward and fell, which you're absolutely right. And then it was passed unanimously.
It was a wrecking amendment, and the other members came on board unanimously because obviously with an election in a year's time, nobody wanted to be seen to be against something like this. when they realise the voting patterns.
But I suppose that where I'm just pushing at with that, and I think you've answered the question directly, and I will, when we come to officers and others, I think it's a key point that we'll need to look at as well. My understanding had previously been that we shouldn't really be in a position for full council to be able to support something that actually is then later being told that it can't be delivered. Councillor Pavlovic.
Thank you, Chair, and I will look to the Democratic Services Manager and the Monitoring Officer. But my understanding of a motion is that if it were to have such significant impacts on the council, that it should not be accepted as a valid motion for council. Now, it's clear to me that the proposal that went to executive was that if you follow the full council motion, which, as you say, was accepted unanimously, it would have such a financial and reputational impact on the council that it should never have got through in the first place. But as you've pointed out, nobody raised those concerns at the time. So my proposition, which I'm making to you, is that the proposal in the two options, the first option should not have been made and was so heavily weighted to executive that it left them with no options but to make the decision that they did.
Thank you. I don't know if either of you just want to make any comment on that.
So the Chair, the test for a motion to be submitted to full council is slightly different in that a motion has to be about services which the council has responsibility for, or it is something which falls within the geographical boundary of the city. And also in terms of financial doability and legal doability, it's quite a high threshold. From there on, that is on the basis that it goes through to full council. So if it's very evidently going to bankrupt the council, or it is ultra vires to do it, there is a stop there from statutory officers. Thereafter, if the motion goes through full council, as this one did, as Councillor Crawshaw has highlighted, it is then for a whole raft of technical professional officers to then look at the minutiae detail in a lot more specific detail about the feasibility and deliverability, and the challenge is then on the executive to try and fulfil the will of full council in the most legally and financially pragmatic way that it can, taking on board the variety of professional and technical advice. But the test for a motion, just to repeat in full council, is it about a service for which the council has responsibility, or does it fall within a geographic area? And excuse me. And also making sure it's not ultra vires, i.e. it's not illegal to do from the get-go, and it is not so financially significant that it is very evident that it would bankrupt the council. So those are the tests that we follow in terms of the receipt of a motion, because unlike an executive report or unlike any other report that goes to council, a motion does not have the benefit of hours and hours and hours of professional and technical scrutiny, because a motion is a political wish, and it's therefore, after it's voted on, that it becomes part of a challenge to the executive to look at deliverability of that motion.
Thank you. That's helpful. I will let you just ask a question. I'm just conscious as we started into that I had said that we weren't going to come into officers at this point. So I will just let you ask a
It's just a technical. It's just a technical question. Where it says in the Constitution that a motion would have to be bankrupting the council, or is that your interpretation?
No, it's part of the Local Government Act 1972, which is the responsibilities of the council, and neither myself nor Debbie as statutory officers can cause decisions to be made that would either place the council in financial jeopardy or cause it to make an ultra vires act or decision.
Yeah, financial jeopardy and bankruptcy are two completely different things.
The test is, would it effectively bankrupt the council? Would we run out of money if we had to do this? And Debbie has a different set of thresholds to judge against than what I have. So, and I'm not an accountant, so I'm sure she put very accountancy speak around this, which I'm not trained to do. But essentially, this is a public meeting. It's not, Debbie's not here, but is it so financially sort of costly to the council that it would jeopardize the viability of the council, which effectively is bankruptcy.
Go on, Councillor Waters, make a comment, and then I can get to these questions.
You've just stated you're not a financial officer, but you are the chief legal officer. Would you like to explain why this motion, as approved, as the corporate director has put in his report, will be difficult to implement legally as regards the local plan?
So I'm not going to comment on that because I don't think it's my role to for this particular meeting. But in terms of, I was asked a question about the motion itself, and on the face of it, it does fall within the responsibility of the council, i.e. it's council service, and it falls within the geographic area of the council's boundary. So therefore, on the test for a motion, it passes that test because it directly affects York and it directly affects the provision of services that we have as a council. That is a test for a motion.
So I think to summarise, because I'm conscious that we're sort of straying off into a slightly different thing, and we do need to just stick within the framework of the call-in. I think that the summary, if I'm correct, is that officers were satisfied that the motion as it was met the tests of the thresholds to be acceptable as a motion. Yeah. They have then subsequently advised executive that if you were going to follow through with the outcome of that motion, it would have these impacts. And the way that they've been framed, and we can get into a discussion about that in due course, has been framed in it would be fairly catastrophic. That's yeah. Okay. So I had Councillor Norman with a hand up, and I had Councillor Musson. Was yours a supplementary to what was being discussed, or it was a separate one? And I've just seen Councillor Vassy as well. Yes. So Councillor Norman.
Thank you very much. I just wanted to get back to what I guess we could call a sort of fit for purpose test, i.e. the essentialness that our policy is fit for purpose going forwards and now. And a lot of talk about the policy not being fit for purpose, and I'm sure a lot of members and the public will have examples in their mind about how it might not be fit for purpose. But I was just wondering if either of you would like to elaborate on specific examples or general case studies of how that policy hasn't been fit for purpose in the past, in your view.
Yes, thank you, Councillor Norman. I think any member that is in a ward that has an issue with HMOs will have received correspondence from residents about issues relating to that HMO. More often than not, in respect of, this was a family house, it's now been sold, it's now an HMO. So we write into planning enforcement and say, can you do an investigation? And that's where I made reference to the 7 cases that are outstanding. I'll just give you an example of one, and I won't give the address for data protection reasons, but alleged unauthorised use. 2019, I got an update saying written to council tax. That is the investigation. 2020, that hadn't moved one iota. I remember writing to the head of planning, and I'm saying, is this it? If you're not wanting to investigate these cases, just say, I don't want to investigate these cases, it's not council policy, and I'll stop bugging you about it. But don't tell me that we have a robust HMO housing policy when I suspect there's a number of members sat around this table that could give a contrary position on that. And that was what the executive were asked to accept. that we have robust policies and that we have robust enforcement, and we do not. And HMOs are a very low priority within this administration and within this administration's planning directory team.
Thank you. Did you want to add something?
Yeah, we're on. It's 5 to 6. I've got 11 years, 12 years nearly of experience of all of this, and I don't want to bore you, so I'll go to that. Probably the latest one, which I look around this table. Some of you were sat on the planning committee for Ambleton Avenue not so long back. I was sat here virtually banging my head on the table saying the figures the officers have given you are wrong. In 2011, I went up in St Leonard's with one of the Hull Road councillors at the time, and we actually got a system set up whereby council tax records send us monthly updates of council tax exempt properties in our wards. I'm a bit loath to actually say that now because somebody will probably get stood on and it'll probably stop. But that's how I was sat here with yourself, Chair. I was sat on that committee and was so adamant that the figures you were presented by planning officers were wrong. Subsequent to the approval of that latest HMO on Ambleton Avenue, it hinged on one property flipping back to C3 status from C4. Immediately after the approval, the council tax exempt properties on Ambleton Avenue went up. We knew what was going on there and the shift in it all, but you were still wrong with those figures anyway. And that, I hope, explains why I was so adamant at that meeting. And that has gone on for the last decade. And I've no doubt that similar things have happened in Hull Road ward. I've watched as Tang Hall has been destroyed as a community, as a working class community.
Yeah, I do recall that meeting, and I do recall being assured that it couldn't flip back because it would require planning permission. And I think it was probably from that meeting that the area planning committee asked Scrutiny to look into the way that the databases are collected, because I think that there was sufficient concern around the table there that the committee couldn't do anything other than take the figures that were at face value on that particular decision. But I think that there was some concern around the questions that were being raised by yourself, Councillor Waters, in that respect. Just going to keep us moving through questions for now. So Councillor Musson, I think you were next.
Thanks, Chair. I had two questions. The first was that we've established that you weren't told that your motion would bankrupt the council. But I wanted to ask if either of you, given that you have clearly frequent correspondence with officers over these matters, was sort of told or indicated at any point to you that the consequences of this motion would have to be coupled by halting the local plan. And the second question, Councillor Pavlovic, you said that you thought that the options presented, I think you implied that one of them was intentionally apocalyptic in order to sway a certain outcome. And I wondered if you could explain a bit more about why you believe that the outcome of the motion doesn't need to be associated with halting the local plan, and why clearly you thought that was actually presented deliberately in that way and not a result of a logistical issue.
No, there was no warnings given at all with the motion. Councillor Pavlovic was wanting to do the second bit. I'll just briefly mention that it's my understanding legally that a supplementary planning document can only assist with a policy. I would argue that policy should have been reviewed years ago, because I've been arguing for that since 2015. That's a matter of public record. But I still don't see why the supplementary planning document can't be reviewed for certain aspects of it especially its operation. I think I sent you the very useful table of how other local authorities operate their planning policies in relation to this subject matter, and ours is clearly failing and has been failing since it was introduced and never changed since 2012 when it became operational.
Just before you start, Councillor Pavlovic, Neil, if you could just make a note of that point around why an SPD can't be reviewed in the way that's being suggested, because I think that that's going to be a key thing that we'll want to explore. Councillor Pavlovic.
Thank you, Councillor Musson. Basically, what I'm saying is that reviews go on all the time. They go on in any number, spatial policy, infrastructure, climate change. They don't involve saying, oh, well, climate change should be part of the local plan, so we're going to have to withdraw the whole local plan whilst we do an investigation as to what's needed. So my premise is that you can do a review, you can do an investigation, you can gather evidence anytime you want. When you've got something to take to the table, that's when you start having to consult. And so the argument that I felt should have been presented to executive wasn't that for us even to start looking into this, to even start thinking about it, would involve scrapping the whole local plan, withdrawing it, saying, oh no, it's going to take you another 6-12 months before we are looking at these 3 bullet points in our 315-page document. What I'm saying is, why can't we just do what council asked for, which was to instigate a review, start a process of work? If you haven't got the staff, say we haven't got the staff for it, and tell executive we haven't got the staff for it. Don't give them a premise that is based on, I would argue, a nonsensical proposition.
Okay, next I had Councillor Bassey.
Thank you, Chair. My question, I think, is primarily for Councillor Walters, though maybe you'll have something to add as well, Councillor Pavlovic. You've plainly done a lot of research here and have studied this at length. So do you agree that the absence of a local plan and its consequent impact on our inability to shape the future development of our city has been a major strategic failure for decades? And part and parcel of that, having read what you've sent us here, can you tell us how many of the local authorities listed here, and you've quoted West Lancs, Portsmouth and Leeds, how many of those who have implemented HMO policies that you're describing already have a local plan?
I wouldn't like to say because I'd be guessing without looking it up, but Leeds certainly have. Leeds is a particularly good example because in 2011, when I was first pushing to get an Article 4 direction in York, that's what I was actually pushing for, was a 0% threshold. So every single HMO will be assessed through the planning system on its own merits. And I was laughed at. I was ridiculed. I was called every name under the sun. And that's exactly the same policy as Leeds City Council operate. Not only do Leeds City Council operate such a policy, they also take the pragmatic view that where streets have got ridiculously high HMO percentages is to allow owners in such streets the ability to escape those streets and sell them again to the HMO market.
So sorry, can I just respond? So you're saying that of these 3 examples, you know that Leeds already has an adopted local plan?
Leeds certainly, but if somebody had an electronic device, I'm sure they could look up whatever else I've sent you. Portsmouth is a good example. You'll be able to just Google in Portsmouth local plan. And I'm sure you'd soon find out.
Okay, thank you.
But yes, the absence of a local plan in York is for obvious reasons, regrettable, but it certainly hasn't stopped the vast expansion of York University and the adverse effects.
Thank you.
I should just be clear as well that we do operate with an HMO policy. We may question its robustness or its suitability or whatever, but the absence of a local plan hasn't prevented us from operating with an HMO policy. And I think the question is, whether or not we feel that it's appropriate and whether or not it needs to be reviewed and in what timeframe. I didn't have anybody else waiting for any further questions. I'll just put it out to members if anybody had anything else that they wanted to ask of the call-in members. Not seeing anybody else. If you could just very briefly just summarise. I mean, I think we probably all know pretty much what you're asking for, which is for the motion, I think, to be enacted. I think that's essentially what your call-in is. But if you want to just give us a quick minute. Apologies. Not to, yeah, sorry, my apologies. I mispresented that. You want to refer the decision back to the executive because you don't feel that the motion has been duly enacted, is the summary of your position, I think. But if you want to just.
Yeah, thank you, Sharon. Thank you for clarifying that. No, what I'm saying is that in my view, is that executive were given options that weren't effectively options, and that they should be allowed to reconsider their decision in the light of a more realistic set of options before them. And certainly, I don't feel that scrapping the local plan is necessary at all. I think that work can be undertaken, and more importantly, it may conclude that the existing draft FD is fit for purpose, and executive of whatever colour can make that determination. But until we have that piece of work done, we'll never know.
Thank you. I don't know if you wanted to add anything further, Councillor Waters.
No, just very briefly to say that dismissing such an important issue which is vitally important for areas around the city's two universities was, in my opinion, complete and utter disgrace. And the way that it was presented to executive was a disgrace. And I'm just hoping that yourselves as this committee right that wrong tonight and send it back to executive.
Thank you both for your time this evening. So if you can step back from the table now, and I'll invite, we have 3 executive members with us. I'm going to try and remember your full titles as you're coming to the table, but please do correct me if I'm wrong. So we have Councillor Waller, who is the executive member for strategic planning and something or other else, I think, and economy. We have Councillor Eyre, who is executive member for finance and performance, and major projects and local plan, and Councillor Craghill, who is executive member for housing and safer communities. Great. So with there being 3 of you and 2 of the call-in, I want to try and keep the initial presentations approximately equal. They, between them, had about 3 minutes each, a little bit over. If you could each keep your initial remarks to 3 minutes, I'd appreciate that. And then obviously there'll be opportunity to perhaps expand on things as questions come in. So I don't know if you want to go right to left as I'm looking at you, or left to right or something.
Thank you, Chair. Thank you for this opportunity to comment. The motion asks for a report, and this has now come to executive in April. It might have come in March, but it had been anticipated that officers would be tied up with a local plan inquiry, and due to the circumstances around the inspectors, it didn't happen then. The report explained in paragraphs 39 to 43 why the review of the HMO SPD couldn't take place alongside the local plan process. There is a current HMO SPD, but the one issue that is hampering it was identified in the planning appeal for a property in Cromer Street, circulated to all councillors on the 5th of May, which detailed that the application, the enforcement of this policy was being hampered by there not being an adopted local plan. And I'll read out that section, that the 2018 draft local plan was submitted for examination 25th of May 2018, and phase 2 hearings are scheduled for May 2022. As this plan is yet to be adopted, it being policy H8 in terms of HMOs, which in this case was challenging the council in refusing HMO, which would have taken that street to 11.5%, in excess of 10%, saying it carries limited weight because we don't have an adopted local plan. And therefore, the important issue here is to ensure that we do get a local plan adopted, and it has consumed many decades to get to this point. The motion asks for the council website to contain data available on the addresses of HMOs and owners similar to other local authorities. This has happened. You can go onto the council website, hmolicensing.york.gov.uk, and you can see online. Therefore, it does comply with the requests of the motion, and indeed it was something that I pressed officers on. Therefore, I think the intentions of the motion have been met. It was discussed at great length at executive. And I think it's important that this is not dismissing the issue. This is actually dealing with the issue within the framework which local authorities have to operate, and the planning processes that take place that are challenged by those people who wish to convert properties to HMOs. And just as we have taken a number of years to pass the minerals and waste strategy with a buffer of 500 metres, which is a national precedence, this has ensured a stronger protection for the city, with it being evidence-based, rather than holding out for a blanket ban, which some members may have wished for, but would actually not have been the same protection. So there's an analogy here that it is better to proceed with the processes that we've got and to ensure that we have a local plan in place. Thank you.
Thank you. And Councillor Eyre.
Thank you, Chair. It feels like an age. I feel like I used to do this every week, and I've not been for a long time. So it's good to be back with this committee again, Chair. I think I'll focus my issues on addressing the local plan. And I refer to the 3 calling members, only one of whom is here. I wasn't aware about Councillor Pavlovich. This doesn't allude to him. I'm well aware that one of those, the one who was here today, has actively been seeking to destroy the local plan for the last 5 to 6 years at least. One of the other calling members is abjectly opposed to the local plan in all its form. And the 3rd calling member was actually part of administration who submitted the local plan, voted for the local plan, and endorsed the policy that he now believes should be abandoned. It's interesting, therefore, that it only appears to be the Liberal Democrats and the Green Party in York who continue to believe that the local plan should be decided by local people through a local democratic process. I've been involved with it over a decade. A huge amount of work has gone on to get where we are today. I'm really looking forward tomorrow morning to give the opening speech as we open the phase 2 hearings. It's a historic moment for the city, the furthest we've ever got, and why anybody would think about jeopardising that at this point is absolutely unfathomable. And I know Councillor Pavlovich made his point about what particular issues threat to a local plan are. York is fundamentally different. York has not had a local plan for decades. York has been arguing over the local plan throughout recent history. The planning inspector has been quite clear. York is at last chance saloon with the local plan. It is not a situation of saying, well, we can pause it for such a period of time. The last correspondence, when we paused it to take further evidence, the planning inspector did say quite categorically, if you want to pause it, you should probably be thinking about withdrawing it. There is no further option for pause. This is York's last opportunity for local, democratically approved local plan. I cannot understand why anybody would risk tearing that up and throwing it away for what is at heart really populist student bashing from an individual. I wasn't sure whether to say that, but we had the same dog whistle politics that I am ashamed to hear in this room when one of the calling members refers to acting on behalf of council tax paying residents. We know what he believes when he says he acts on behalf of council tax-paying residents. He doesn't act on behalf of students. He has no interest in students. And ironically, those people who work at the university, one of the largest employers in the city, and part of the economy that thrives on those individuals, I welcome them to the city, and I'm ashamed to hear such comments at this table. If the local plan is paused, if the planning inspector refuses to accept any pause on the local plan, the plan will be decided by central government. And when distribution of housing, how many houses are built, where those houses are built, what impact there is on the Greenbelt, what the impact is on employment, and ironically, what the policy on student housing will be, is all decided in Whitehall by an individual we don't get to talk to. Every single person who has suggested that will have to answer to the electorate as to why they wanted to do that. It's also worth noting, as Councillor Waller alluded to, the planning inspector just absolutely ignored the 10% threshold when making the recent appeal decision. He took it on balance. He said, yes, it's appeal. 10% is a guidance. I look at the guidance. I don't think it's an issue. I'm happy to approve significantly more than 10%. So anybody who thinks reviewing this policy, risking the local plan will do anything other than lead to worse policy making, worse policies around climate change, worse policies around HMO development, things that don't reflect the uniqueness of York, you are very much mistaken. Thank you.
Thank you. And Councillor Craighill.
Thank you. I think I have a little less to add just from a housing perspective. Obviously, it is about housing, really, but it's a planning policy issue. I do believe HMOs are a very important part of the current housing offer in the city. I just wanted to remind us of that. Whilst many are occupied by students, as Councillor Ayres just said, students are an important part of our population, but HMOs are also part of the housing offer for young professionals and other low and middle income households, as the paper says at paragraph 7. I appreciate there are concerns about HMOs from residents, both from the point of view of community impact and with respect to the standard of accommodation for the occupants of HMOs. Both of those aspects will be significantly addressed if the council does approve the extension of HMO licensing at executive in June. And that, of course, we will, that is a decision yet to be made. But the current statutory licensing of HMOs with 5+ occupants has been very successful in York in both improving the quality of that accommodation and improving the management of properties, which helps to reduce negative impacts on neighbours. So there is a potential for that to be extended quite outside of this policy we're discussing today. The key issues in this paper are about planning. In that context, I believe the decisions set out in the paper taken following legal advice are the right ones. As Councillor Ayres just said, the last thing we need to do at present is to jeopardise the progress of the local plan through to adoption. From a housing provision point of view, obviously it is the local plan that's going to deliver much of our future affordable housing. And I think the last thing we want to do is to have to wait another 4 to 5 years for that to be put properly in place. The paper to executive provides a clear explanation of why the review shouldn't take place before the adoption of the local plan. It's in paragraph 37, it's in detail in paragraphs 41, 42 and 43, and makes it very clear that initiating a review of local plan policy H8 would require a request to suspend the current local plan examinations and could lead to a withdrawal of the plan. I do agree, as the paper says, that an overarching review of the policy could take place once the local plan has hopefully been adopted. I also agree with the paper at paragraph 43 specifically that such a review should start with an open mind, be evidence-based and not be predetermined in terms of its recommendations. With respect to the second call-in reason, I'm sceptical regarding the assumption in the council motion that the problem is the current percentage thresholds. It may be, but we really haven't heard anything to support that contention. Evidence seems to point far more towards the problem actually being more to do with accurate data collection and management, and also the standards of accommodation in some HMOs, both of which are now being addressed as the executive paper sets out. So I do think there's quite a bit of confusion when you talk about the policy not being fit for purpose. You're actually talking about other aspects which are addressed in the executive paper. So I do agree that the current policy is robust. So I don't agree with that call-in reason either.
Okay, thank you all very much for your opening comments. I've got Councillor Musson had indicated. I'm just looking for any further. Councillor Baker. I'm just going to jump in first, just with a quick question, which I think probably, to my mind anyway, is sort of at the heart of what the call-in members were saying. So obviously, as executive members, you all voted to initiate without delay a review of HMO supplementary planning documents, and then subsequently were advised very, very strongly by officers that that wasn't a course of action that you should take. So in my mind, what you would then do would be to robustly interrogate the officers around why they were making that recommendation, or satisfy yourself that you couldn't actually take forward the thing that you had publicly voted to do. So could you just let us know a little bit about how that conversation went, what's the challenges were that you put to that initial paper with those two options? Because I think my reading would be similar to Councillor Pavlovic, that it did feel to me like here's a catastrophe and here's carry on as you are. I just wonder if you could elaborate on that.
I mean, that's misrepresenting what the paper says. I think Councillor Craghill touched on the point I would make, is there seems to be a lot of confusion around policy implementation. What that initial review and the paper officers produced showed was there was a significant issue with implementation of the policy, be that about the robustness of data, be that about HMOs are being managed. And as the paper shows, there were significant steps being taken to address that. Whether they work or not, I'm not at liberty to say at the moment. Clearly, the evidence that the calling members have said is that it's not as it should be now, and we'll have to look at that rolling out. There's further things happening, the licensing, etc. That review and that paper provided no evidence whatsoever to contradict the policy that we took several years, and by recollection was supported by all parties in York, with the exception of Councillor Waters, who wouldn't vote for students even if they were giving him a fiver. But that policy has never.
Be a bit careful with your comments, Councillor.
That policy has never was put forward. No evidence was put forward to suggest it. The evidence officers had was in a complete absence of evidence to go into a planning inquiry saying we have no evidence that we don't support one of the key policies of our local plan. However, we are going to instigate a review of it just for the sake of it, would be hugely damaging and call into question our plan making process. And as the calling members said, if the review shows evidence, we should review it, and then says we should review it at the start with no evidence. If there is evidence, it should be reviewed. It should be reviewed, and it shouldn't be in the local plan. There is no such evidence. That's why it is in the local plan. We could instigate review on every single policy and say, well, actually, I'm not sure about that policy. I'm not sure about that policy. I'm not sure about that policy. Let's spend an inordinate amount of time and resource reviewing 7 or 8 policies within the local plan. At the same time, we're asking a planning inspector to see it as sound. Would you see a policy as sound if the body that was putting it forward said, well, actually, we're reviewing several of the key policies in it while you're looking at it as well?
Well, the review is to review the supplementary planning document, isn't it? But I think in that answer,
supplementary planning document is the policy.
You haven't answered the question that I asked you, which is that the 3 of you, and I think everybody around this table, all put our hands up publicly, saying that we were voting to initiate without delay a review of the HMO supplementary planning document.
Which has happened.
Sorry?
Which has happened.
So you're saying that the supplementary planning documents have been reviewed?
There has been an initial officer opinion review of the planning documents, and their view is, on paper, on the evidence they have, they should go forward to examination, which I agree with.
And they were to be reviewed with a view to halving the acceptable percentage thresholds of HMOs across the Article 4 direction area. So they were reviewed with a view to reducing the acceptable percentage.
I mean, you should never start any review with a review, but
well, you voted for that, didn't you?
So did you. And
yes, I did. I did. And
that says a lot about any of those 47 members.
That's my question to you. to the three of you, you have subsequently taken a decision which appears to invert or to disregard the position that we all took at full council. And that's your gift as executive members. And it is sometimes the case that an officer might recommend something which doesn't perhaps follow from what the thrust of emotion was, but for various mitigating circumstances. But I would have thought that if you were only a few weeks later about to take a position which appeared to be contradictory to the position you'd previously taken, you would want to interrogate the advice that you were being given very robustly to make sure that you were absolutely on clear ground. And so the question I'm asking you is, how did you interrogate that advice? Were you happy with those two options as they were presented to you? Because my sense is that, as I say, Councillor Pavlovic has framed it as being a sort of here's a catastrophic option and here's as we are option. And common sense would suggest that there ought to be some other options in between those 2 points. My question is, what did that conversation go like?
It's a matter of public record. You're on the executive. We have they're all conversations. I mean,
no, you had a
this
public record with those two options. But what I'm saying is the point at which you're presented with those two options. We all know reports come forward in draft. You see them. The first time that executive sees a report is not when it's published on publication day. So you will know what the options are likely to be. And there are opportunities as executive members to challenge officers over the positions that they're going to put forward. And I'm asking you to give us some flavour of any challenge that you may have put to those two positions, given that you've been forced into a position of appearing to do an about turn on the very public vote that we had on, I've forgotten the date now, but in December.
After this meeting, Councillor Corshaw, I will walk to the car park with a view to driving home. If anything happens on the way, such as a flat tyre or a closure of the road, I will not drive the car home because of that. Having a view to do something does not mean you continue to do it. Circumstances change, things change. At the point of, are you going to interrupt me again? I mean, I'm quite happy to allow you to just talk to the meeting, or if it's going to be a question and answer session, you do need to let me answer. Time and circumstances change. The position of the local plan changes. We are at hearings tomorrow to progress the local plan. That was not the stage at December full council meeting. The advice of that full council meeting may well have been different had we been going into a local plan inquiry at that particular time. At that particular time, we were at March. You then take a review and say, well, actually, can anything be done? Which actually, I believe, was a lot of the suggestion was that could be done in a 6 to 8 week period ahead of the local plan hearings, which is something that officers will go away and look at, decide whether that can be done. If it's a fundamental review of the policy, that's something different. That is the process you go to. Times change. At that point, the executive made the decision, knowing that we're going to a local plan inquiry. That is what I based my decision on. And I stand by that point that I do not believe that is the right thing for the local plan to start questioning key policies right ahead of going into local plan hearings. That is the interrogation, that's discussion. I can have many discussions with officers. Officers all believe the same thing, that is not the right approach to take going into local plan hearings. You disagree, Councillor Pavlovic disagrees. Councillor Waters, I don't think wants a local plan to succeed, so he's quite happy to progress in that way. But the clear advice we have, the clear view I have, and the clear output of those conversations is that that would threaten the local plan. And let's not beat around the bush. The inspector wrote in candid terms and said, this is your last opportunity to do this yourselves. He has since that point questioned twice further delays around gathering further evidence as part of that process. Patience is wafer thin with the planning inspector in terms of getting this local plan through. So while in a different situation, as Councillor Vassie alluded to those authorities that have local plans and looking to review, or those that are at early stages or submitting a local plan that's a refresh of a 20-25-year local plan, is different to a local plan in the city that's been over 50 years, has not been approved from a planning inspector that has quite clearly said to York, this is your last chance. We want to take it off you.
Your point,
you have to get this over the line.
Thank you. I'm afraid I still feel that you have rather missed the point of the question that I'm trying to ask you, but I don't feel that we're going to get anywhere with it. So I will go on to Councillor Musson.
Thank you, Chair. Before I ask my question, I just wanted to say if we could keep the call into, the subject of the call in rather than comments about individuals, and stop straw manning people, because you've repeated an argument against a position that the call in doesn't take numerous times. And I feel like it kind of is a bit of a waste of time, as well as being a bit dishonest, to be honest. My question is on a statement made by Councillor Craghill, which is that she believes that the impact on the community, which the papers say, is one of the aims of the HMO policy, is to prevent, disproportionate impact on the community, will be addressed by HMO licensing through, upkeep of standards in HMOs for the tenants. And I wanted her to explain what she meant by that, because I wasn't aware of that feature in the licensing process, proposed licensing process.
Well, the licensing process is all about improving the standard of accommodation in HMOs. So it looks at a number of things. It looks at energy efficiency standards, it looks at space standards, it looks at the general upkeep of the property, etc., all those sort of things you would expect. It also looks at the management of the property. So it includes the development of a management plan which can be enforced. So if you're asking how does that impact on neighbours and how the HMO impacts on the neighbourhood, it would a large part of the answer to that is through the management plan, which has demonstrated with HMOs licensing of 5 or more properties with 5 or more occupants, which is the statutory licensing that's already in place, has demonstrated that sort of improvement, in terms of how the external part of the building is managed, how students live in the building and interact with their neighbours and manage their rubbish and all that sort of thing. So that's what I was referring to. Does that answer your question?
It doesn't. I think my question was about the papers themselves referred to the HMO policy should be to manage the supply to avoid high concentrations of this use in a particular area. And I think there was an implication that this purpose was covered by licensing,
right?
And it's not. And what you've just said doesn't include that at all. So I wanted to understand why you're making the statement that the licensing policy would address that function.
Right, so I wasn't saying, and I don't think I did say, that the licensing policy would on its own would replace this policy. Obviously, it isn't replacing this policy. This policy is still here and is being used. That's kind of the point of this discussion in a way. I was saying, as I think it does say somewhere in this paper, I'm not sure which paragraph, it does refer to the licensing policy, if that is extended further, if it is, as June executive, to HMOs with 3 to 6 occupants, 3 and 4 occupants, it will be a significant help in terms of the impact that HMOs have on neighbourhoods. I'm not for one moment suggesting it's a replacement or the only solution.
I mean, officers can confirm, but I think one thing licensing does do is improve data collection and improve knowledge of concentration. At the moment, we rely on certain tools to know where HMOs are, which Councillor Waters has accurately pointed out isn't always the most robust. Licensing will help, I believe, and officers confirm that, with identifying where HMOs are, therefore having a more accurate picture of what those percentage thresholds are, to try and avoid some of those decisions that people believe are 8% when they're actually 12 to 13%.
You just sort of said that the HMO policy wasn't robust in collecting accurate data and that we needed HMO licensing to be more robust. So you've kind of proven a point of the call in there that...
No, I said the policy is fine. Data collection policy is 10 to 20%. There's then a question about how you identify whether 10 to 20% are, and your data collection can always be approved. A policy is a policy, it's then implemented. As I said at the beginning, there are clearly issues with the implementation of the policy, and that's what we're looking to address. That doesn't mean the policy is failing if you fail to implement it.
Yeah.
We can have a policy of 0 carbon. You then have to get to that point with an action plan of getting there.
I would totally support that, Chair. There's been some very confused discussion on that particular point. The policy is the 3 points that it says are the policy at the back of your papers, you know, the 2 thresholds and the impact on resident amenity. The other issues about data collection are about how you implement the policy.
And evidence your policy, presumably. And evidence your policy, presumably. So you have voted to say that your policies are evidence-based and robust and fit for purpose. And I'll concede, you know, I'll happily say that you believe them to be robust and fit for purpose. But if you think that the evidence base is not there, which I think is what you were just saying.
But changing the policy
Yes.
isn't what changes the evidence base. Taking action on improving the evidence base, which, as the paper describes in some detail, is already being done, is what improves the evidence base, not changing the policy.
It's one thing to say you have evidence that the policy should be 10 and 20%. It's a different thing to say whether you're actually granularly collecting the data to accurately say on each decision, which you found at planning, whether that is a 10%, 9%, 11.2%. If a HMO is a HMO where it's not been identified, that doesn't change the evidence of the policy. It doesn't mean 10% is wrong. It means that your ability to measure the 10% is currently not as accurate as it perhaps could be and could be improved, which always can be improved.
So again, I'm going to take us back and I'm going to try one more time, and perhaps either Councillor Waller or Councillor Craggill could answer, because you both have voted to reduce the thresholds down to 10% and 5% from 20% and 10%. And then you've been told that you can't. So again, how have you challenged the information that's being presented to you? Because I'm quite sure that you will say to us, and I think, you know, reasonably, you've made the case previously, you know, in different call-ins, that as executive members, you rely on the expertise of officers to present information to you to help guide you in your decision making. And I don't think that there's anybody who would question that. But I think that in your evidence and information being presented to you, if it is perhaps advising you something contrary to what you've previously thought, you might challenge it, you might question it. So we're back to that same thing of you have been public in saying that you think that we should be reducing the thresholds.
Review with a view to.
Councillor, specifically I'm asking for Councillor Waller and Councillor Craggill to comment on that.
Quite happy to answer that. We voted, as you say, for an amended motion that said with a view to reducing thresholds. I don't have the exact wording here. I voted for that because I understand there are concerns about HMOs, and I was happy to support looking at the issue. The paper that we had presented to us at executive, which you have in your papers, is very detailed in its explanation of the issues around, you know, the impact on the local plan and the whole process. So I think it's perfectly reasonable for us as executive members to read that carefully and to accept that argument, which does also include, you know, paragraph about the potential to review the whole, to take an overall review of the whole issue once a local plan has been adopted. I'm also very much of the view that review should be an open review that doesn't prejudge what the outcome should be.
Okay, thank you, Councillor Waller.
Thank you. The motion asked for a number of issues to be followed up, and I did press officers on the public data, looking at other authorities, and people emailed me saying, oh, this council presents this information, and therefore I'm glad that we did get to the point where that information is readily available on the council website. In terms of looking at a review, yes, that's having a report that comes to executive was a part of that, and officers were asked in great detail why there would be a threat to the local plan, and that's why I raised in my initial submission the comments from the inspector that by not having a local plan, we were in a weaker position as authority to refuse planning permission for HMOs in streets where there were already that number. So I think it was an important issue to cover and to review, but this is where we are. It would have been we'd been in a strong position if the government had leapt into action in 2018 and as we submitted the local plan that they appointed inspectors immediately and we had the public inquiry over and done with then.
Thank you. Councillor Musson, I saw your hand go up, but I wasn't sure if it's supplementary. If it's not supplementary, I've got Councillor Baker who's been waiting for ages.
It was in response to a comment just made in that question. I would like someone to clarify because they've said something a bit contradictory.
If you could, and then I will bring Councillor Baker.
Just a few minutes ago, Councillor Craggill said that she wasn't aware of anyone that had a problem with the threshold itself. And then in her response just then, she said she was happy to vote for the motion because she had heard concerns about the threshold. So I'm just wondering whether it is that you have heard concerns about the threshold or not.
I didn't say I had no concerns about the threshold. I said I've seen no evidence anywhere that indicates what the right answer is in respect of the thresholds, which is why a review after a plan is adopted would, look at the whole question. I voted for the motion as amended because I wanted to support the general desire to look at this issue, because I know that residents are concerned about HMOs. So it makes sense to ask officers to consider that. I don't think that's...
Thank you. Councillor Baker.
Thanks, Chair. It will be quick because Councillor Craggill has answered my question. I think she is in support of a review when the local plan is adopted. So just to Councillor Waller and Councillor Eyre, is that something that you do support? And obviously reviewing the policy and the SPD and then gathering the evidence and deciding what to do, is that something you still support and will go ahead with?
Yeah, I think in terms of the local plan that was submitted in 2018, time has moved on, but it's much better to get that local plan through the process and then look at what across the whole gamut of policies that you would want to refresh, and this certainly would be one of them.
Yeah.
I think from my point of view, I think both colleagues have alluded to it, and I say the calling members alluded to it, there is an issue with how HMOs are being managed in the area, and that's all the issues that were raised by the calling members, and none of them were around the policy. And that's what I was keen to see in this report, all the steps that are being taken to deal with some of those issues, deal with the data collection, making sure it's more robust. As I've said repeatedly, that should be reviewed, that needed to be reviewed. Will it have the desired impact? I don't know. That's something we'll have to wait and see. If in 18 months' time, these policies have come in and all of the issues the calling members have raised and the examples they've gave would all have been potentially mitigated by these, if that happens, then we will be in a situation where the policy is fine and the implementation of the policy has solved the issues. If in 18 months' time it comes to a point, well, actually, no, we've done all that, all those issues, we've got all the data right, we're still doing that, but we are seeing an issue that 10% is too high, 20% is too high. But at the moment, the evidence isn't there, and evidence isn't there to instigate the review of the policy. So yes, fully supportive of making sure that we get the implementation of the policy absolutely right and continue to monitor all the policies within the local plan as we go forward. As Councillor Waller alluded to, time has moved on. We've declared a climate emergency during that period. That wasn't in place as part of the actual proposal of the local plan. So certain policies around that will need to be reviewed going forward. The question will be, the local plan, as I've always said, is a starting point, and York has spent far too long arguing about the starting point. We need to get to the starting point established, and then we can look to prioritise which of those policies we need to review the quickest, be that HMO, be that climate change, be that transport, be that housing, be that employment. There is huge amounts of work to be done once a local plan is adopted. But if we don't adopt it, we will A, be wasting a lot of time and effort, and B, we will just literally hand over control of the development of the city to somebody who has no connection whatsoever.
So I'm just going to jump in again just before Councillor Norman's question, just to clarify a couple of points on that. I still feel a little bit confused as to whether or not you think that the review of the HMO SPD has or hasn't taken place, because I think you said that it had taken place, and then Councillor Craggill has suggested that it hasn't and it shouldn't be prejudged. And So I think we're sort of into a bit of a thing around there. But from looking in the paper and from looking at something of what's just been said as well, are we suggesting that we are not reviewing any SPDs at this moment in time and won't be reviewing any SPDs until such time as a local plan is adopted? Because I thought that we had begun a climate SPD and I thought that we had begun a transport SPD. I can't remember, there was two I think that we did through the budget. Housing, apologies, housing. So are they suspended at the moment? So they're ongoing, okay. And if what you're saying is that when we get to the end of the local plan policy process, we'll then have to sort of prioritize what order we look at the various SPDs that we might want to review subsequently. So what time frame do you envisage? Ballpark, I mean, I appreciate we're all crystal ball gazing and it's a little bit difficult, but let's say that we get the local plan adopted in the next 18 months. Would you envisage that we would then be looking at HMOs in a couple of years' time, 5 years' time, 10 years' time? Have you got a sense of, in your mind, what's your sense of where it might sit in the pecking order and when that SPD might be reviewed once the local plan has been adopted?
I look forward to your view that I will be still in charge of the local plan in 18 months' time. It's a ringing endorsement I take.
I don't think I said that. I think I just said that.
Are you asking what I'll be prioritising in 18
months'
months' time, Councillor Corsial? I look forward to putting that in my manifesto. It's not something you can crystal ball gaze. As I said, as we look to implement some of the issues that we've been put in this paper, that may solve the issue, at which point we may say, well, actually, having looked at that, the number of complaints to councillors has gone down. The issue seems to be well managing. Licensing has taken off. It's been fantastic and that's working really well. Clearly, the 10 and 20% threshold is absolutely fine and we don't seek to change that in any way and we don't need to review it. Everything in this paper may fail catastrophically and we may go, actually, the situation has got considerably worse, not better, therefore we need to prioritise it. I suspect climate change will be one of the ones that we do prioritise early on in the process. So it's very difficult and it will be down for that administration when we take over to decide those, as you paraphrase your former leader.
Thank you. Councillor Norman.
Yeah, just very quickly, and apologies if this is a foolish question, but could it not be policy for us to enforce and collect data in certain ways? And I don't want to prejudice any potential review, but if those things are so fundamentally flawed, which I, as a ward councillor, would suggest that they are reaching that stage, that they need such serious review, would it not be sensible to not leave it to the whim of individual executives, past, present, and future, but instead to insist in policy form that we collect data and we enforce the policy in certain ways? And if those could be considered part of the policy and potentially reviewed, maybe, could the policy review therefore not only review the elements you've been discussing, but go further than that in how it reviews policy?
I mean, I don't think you need to review the policy in terms of data collection. The policy is 10-20%. The question is, how do you obtain that data? What information do we have? So, for example, council tax records, the students being exempt from council tax, that gives us a clear indicator of which are student HMOs because they're not paying council tax. Since the Article 4 came in, planning it gives us more data. Those that were pre-Article 4, we have no data on. That question is about how you collect that data. We can't put in a policy that would say everybody in a HMO has to write to the council and tell us that sort of thing. It's how you use that, and that's why the licensing issue comes in, which gives us an opportunity to get that data. That's my point. It's not a policy issue. We can just get on and do it and get all the evidence that we possibly can and take steps. And that's what we are doing, is to say that we will do all we can to get as robust a data as possible.
Thank you, Chair. I think if we can on that point move forward, that I receive as executive member regular updates on planning enforcement, and I have been working very closely with the relevant manager to ensure that there's a fully operational team doing a wide range of planning enforcement issues, and there is a public consultation which will be ongoing in terms of all enforcement issues, and Councillor Craghill was at the joint decision session where that was set off. So I think it would be useful to get your experience as a local ward councillor, and I'm sure other ward councillors will input into that, in terms of how the planning enforcement team is working for you and for your residents in terms of delivering the collection of data, the enforcement of existing policies. Happy for that to happen.
I think one thing we always have to be mindful as well is personal privacy and personal safety. I think one of the concerns I've had throughout this process is that you don't want to reach a situation where the council is listing HMOs on a street by street basis, and then you, in essence, creating groups of people wandering around peering through curtains, trying to work out and ascertain and contact the council and say, I think my neighbour's a HMO, or I've been spying on the person down the street and I think there's 5 people and I don't think they're related. I really don't want to get in a situation of some sort of surveillance culture that tries to identify HMOs.
Is that a supplementary question, a new one? In which case I've got Councillor Vassie. Oh, Norman, did you want supplementary? So, Councillor Norman.
Yeah, thank you. Sorry, just because I think it's wandered off the point a bit. I think my point really is fundamentally, you seem very narrow in your definition of policy, and that worries me deeply. And that it just strikes me that if you're going to review policy, you don't say that how we enforce something is nothing to do with the policy. It's fundamental. When you write a policy of how you're going to do something, you absolutely write how you're going to enforce it. What kind of policy doesn't have within it how it's enforced?
Can I say that? I'll say something else next, but I would suggest first, Councillor Norman, perhaps you put that question again to officers to clarify. But as far as I understand it, and I think, and it says in the paper, you know, although the motion referred to reviewing the SPD, if you want to change thresholds or anything like that, you have to review the policy, which is policy H8 in the local plan. And that sort of policy does not tend to have that sort of operational detail in it, but maybe it could at a future review. I don't know. As I say, I would suggest putting that to officers as well.
Yeah, I think it's page 25. Policy H8 is there. It's 3 bullet points. That's what the call-in is asking for, that to be reviewed. And as you say that my definition of policy is the call-in is even more narrow than that. The policy is review it and review 1 and 2, quote, with a view to halving. So it's not about the implementation. It's not about identifying. It's not about dealing with the issues in a neighbourhood. It's about deleting on page 25, 20% and replacing it with 10%, deleting 10% and replacing it with 5%. That's what the call-in was asking for. That was the impact that we discussed with officers. And that is why we take the view, I take the view personally, as my colleagues do, that doing that at this time would be hugely damaging to the local plan.
Councillor Vassie.
Thank you, Chair. It seems to me the executive position is that this is all about timing and the critical pathway for getting the local plan approved. And a question really for Councillor A. You said you've been working on this for 11 years. And I'm assuming you know a lot about all the obstacles and pratfalls that have existed in that time and going back decades into the past. So it would be helpful just to get an idea of what those pratfalls have been, why it's been so difficult. And you made a comment that we've got further than anyone has got before. And maybe just giving us a sense of what that means and how close we are to finally signing off on this document that York has apparently been unable to sign off for over 60 years.
I've clearly blanked out periods of my history because it was actually 15 years, Councillor Vassie, not 11.
Oh,
So
right.
it's been even longer. And I say that's just my involvement. So I did actually sketch down because I was trying to think when I said it, all the various iterations. So I think 2011 was the first submitted local plan of my tenure, which was a Liberal Democrat submitted one. That was just prior to the election that year. And the following year, the control of the council changed. That plan was withdrawn. an amended local plan was put in at that point, a minor amendment to that one, which is the situation that we're in. And this is why I reiterate the planning inspector is losing patience. That sought, I think, to change the housing from about 750 to 850 in 2011. That was then subsequently withdrawn again due to the issues around Vanguard and the planning application that was submitted for the Vanguard and Community Stadium, which was not in the local plan. So the 2011 plan was withdrawn. That was resubmitted again around about 2013-ish, I think, with a significantly higher housing number going from 850 to about 1200, I think, at that particular point. And I was reminded of this when Councillor Crawshaw was asking a question about what can and can't a council motion do. And surely a council motion wouldn't be passed that would have something so catastrophic as stopping the local plan. Well, in 2015, a motion was passed by the Liberal Democrats and Conservatives and the Greens to stop the local plan. That was the actual motion itself, was the council will withdraw the local plan because it's not evidence-based. So that local plan was withdrawn on the basis of a council motion in 2015. We have then worked tirelessly since that point to get the submission that we got through. The one thing our reflection is it has been hugely political. The change in administration has never helped. The one thing I would say on that is at the start of that process that I was there, the regional spatial strategy, which was the starting point, gave a figure for York of about 850. We've oscillated through various administrations between that, and we've ended up with a figure of around 850. The employment data for York also pointed to a figure of about 850. So all of that oscillation in essence has changed very little and moved us towards a point where we could have been at significantly earlier. The jeopardy is, under the current regulations, if the local plan is withdrawn, we will not only will we no longer be in charge of the local plan and the government inspector will be in charge of it, we change from the current methodology of how the local plan should be developed to the new methodology, the new methodology. There's been 3 different methodologies put forward since the time the local plan has adopted. We would have to abide by the one that is in place at the current moment. That one is the one that shifts all the housing from Conservative wards in the south and puts them all into Labour voting wards in the north, and would increase constituencies and would increase the housing requirement for York from the 850, which has always been around about the statistical average, to about 1250. So a 50% increase in land grab if we were not able to get this local plan through. And that is the jeopardy. And I know Councillor Crawshaw asked me to what level of conversations have I had with officers around that. I know more than anyone the jeopardy of not getting this local plan through. I've probably been here longer than Neil has in Elmston, had more involvement with the local plan than Neil has in that sense. So I can tell him a lot more about some of the jeopardy. The Greenbelt issue goes back even longer, 30 years, I think, was the point where that was what stopped the last iteration of the local plan, was the planning inspector was not happy with the Greenbelt boundaries, and that's why he withdrew it. And that's why I say there can be no further withdrawal. The planning inspector cannot have been clearer. You have submitted and withdrawn this plan so many times. It's like the hokey cokey, as Councillor Waters, I think, has said previously. This is your plan. You either go ahead and let me inspect it, or you scrap it. We start again. Our rules, our officers, and it's no longer anything to do with you.
Can I ask a quick follow-up?
A quick one, and I've got Councillor Musson, and then what I'm going to suggest we do is we take a 5-minute adjournment at the end of this section. So if anybody else has got any questions for exec members, if you could just indicate now. So I've just got Councillor Bassey and then Councillor Musson.
Yeah, I'm wondering if you know how many local authorities in this country don't have an adopted local plan. Are we in good company? Are we in bad company? How do we fit in with the big picture?
I haven't got the data, but I would probably say sticking out like a sore thumb. We are nationally known and nationally observed by the planning inspector as a massive outlier.
I think on that point, there were less than 10 mentioned by the Secretary of State when the local plan for York was being called for. And in terms of getting close, I was put on the Greenbelt Working Group for the previous council in 1994, as we were close to having an agreement on that, and then local government reorganisation happened, and the development of a local plan was closed. Then government changed its mind and said, no, we'll have local development frameworks. And then we got close to developing a local development framework, and they said, no, go back to having a local plan. So there has been casual appliance of central government thinking which has interfered with York getting this close. But we certainly haven't been this close since I was 24.
2 years ago then.
Thank you. Councillor Musson, and then, as I say, I think we'll then go to an adjournment.
Thanks, Chair. Following a rather lengthy discussion about what would happen if we scrap the local plan, despite previously talking about how the call-in never asked us to scrap or pause the local plan, I'd like to follow up, if I may, on, I think Neil was mouthing that we were having 2 SPDs into climate and housing. Is that correct? Yeah, I just would like to understand, as someone who is not very knowledgeable about planning documents, why this SPD would mean that we'd have to pause the local plan and those wouldn't, and why we're comfortable doing those and not this one, and why that means that the local plan's going to implode.
Because unfortunately,
Sorry, Councillor, I think that's probably a question for Neil rather than a question for exec members. So I'm just slightly conscious of time and people wilting a little bit and all of that. So if you want to give a very, very brief answer to that, but I think that's probably something that we would be better off addressing.
The simple answer is because the call-in doesn't ask for review of the SPD, it asks for review of the policy, and SPD should follow the policy. If you have...
No, we need to be, let's just be clear about what the call-in is. So the call-in is on the decision reached last night does not satisfy the will of full council with regards to the motion approved on 16th of December. And then it goes on to say it doesn't provide an explanation for why the review of HMO SPD cannot take place, indicates that the current HMO SPD and its use when assessing is robust, etc.
It calls for changing the policy. It calls for halving the policy threshold.
No, the motion does.
Yes.
So that's the nub of where we've been trying to get to. So we've all voted for that motion. We've all agreed that. That's the will of full council.
It calls for a review of the SPD with a view to blah, blah, blah threshold, but it calls for a review of the SPD, which we are apparently doing or on 2 other SPDs is my question. So what's the difference between that one and the other 2 that are happily trucking along without pausing the local plan?
The issue of compliance. Neil will go into detail, but it's the issue of compliance with the local plan.
Pardon, could you just repeat that?
The compliance with the local plan of the SPDs.
Right.
So I think what you're saying, if I'm correct, and we'll get into the detail of this with Neil, I think the argument that you're making is that the local plan policies on those other 2 issues are in place. The SPD is about implementation of those policies. And the argument that's being put here is that to review the HMO policy with these thresholds would require the policy within the local plan to change, and therefore it can't be reviewed until such time as, yeah. Okay. On that note, shall we have a 5-minute pause? I make it 7:05, just slightly before. I don't want us to be here all night, so let's just make it literally 5 minutes. Come back at 7:10. So thanks to the 3 exec members. And when we come back, it will be to have Neil, any of the questions that he's picked up, and us to ask any questions of Neil, and then on to the next parts of the calling. Okay, thank you all. Right, welcome back, everybody. We are midway through, well, hopefully a bit more than midway through our call-in this evening. I'll just move us straight on to Neil Ferris as the Corporate Director for Economy and Place. You've been listening to the case that's been made by the calling-in members and the executive members. I think there's been one or two technical questions that have come up, which if you could address them now, and then if members have any further questions for you, I'm sure they'll put them.
Thank you, Councillor Crawshaw. So just to start off with, in terms of the reference to CMT of council resolutions, the original resolution from Councillor Waters, I would just note, required executive to consider initiating without delay. So it was a slightly different piece in terms of the original resolution. It was amended, I believe, by a Labour amendment. And now clearly those amendments are last minute, and as Janie has said, they have a very high threshold in terms of what that means for the authority. And I think as Councillor Eyre pointed out, the actual withdrawal of a local plan isn't considered catastrophic. That is entirely a matter for members to determine. You determine whether or not that is catastrophic or not, but clearly from a central government perspective, the planning inspector has outlined the consequences for the authority of effectively withdrawing.
Would you mind just moving your microphone over a little bit? It's just
withdrawing
withdrawing
the application, with withdrawing the local plan. But I'd note as well, in terms of just translating the actual full council resolution into the executive report, that when you look at the options that were presented to executive, 37A, it doesn't say that the local plan would fall, and it doesn't say the local plan would be withdrawn. It said ask the planning inspectors to suspend the current local plan examinations and consider if the council's proposed to amend policy H8 would be a main modification, and subsequently would this be considered a withdrawal of the plan. So the option for the executive was one, it was well within their powers to withdraw the plan. Secondly, it was to effectively ask the inspector as to whether it would be a main modification or not. Councillor Eyre has highlighted the executive's view was that they didn't want to go to that stage of actually asking the inspector as to whether or not it would be a main modification. In terms of why it would be classed as or potentially classed as a main modification, well, it's for the inspector to determine the process as to whether it would or would not require an amendment. But as you rightly pointed out, Councillor Crawshaw, because the policy H8 is actually part of the council's local plan policies, then the request in respect of the the proposal from full council to amend the supplementary planning document is that it would have the effect of effectively setting aside policy H8, because policy H8 supplementary planning policies have to effectively add to and implement the primary policies of the local plan. They shouldn't seek to amend, they can't seek to amend them. They have to reflect the primary policy. So effectively, the proposal that was ultimately resolved by full council in respect of, and I think it's the point, is the halving the acceptable percentage thresholds. That was the request that was made to executive. That would be the request that executive were asked to pose the question to the planning inspector. We would like to halve the acceptable percentage thresholds, and would that be classed as a main modification? The challenge from that, from an officer's perspective, is, well, where would the evidence base be to halve the impact? And suggestion as to that evidence base was, well, one, there isn't any evidence base. None was provided to members in respect of the amendments, or indeed the original proposal, because as Janie has said, it is not for officers to effectively interfere with the political will of the authority. It's members to actually determine how they wish to play out their political ambition for the city and then make the decisions, and it's our role to inform as to the consequences of those decisions. So withdrawal of the plan is not ultra vires. You can do so. It has consequences. It has consequences in terms of resources, etc. But it's within your right to do so as an authority if you wish to do so. So then the question was also made as to, well, it isn't material. Why is it going to have an impact? Well, one, I've just made the relationship directly to the actual planning policy itself. But in the submissions made by Councillor Pavlovich and Councillor Waters, there was rhetoric or conversation there about the strategic housing needs assessment, the fact that we had a significant problem with student population distorting our overall population's growth and statistics. Student populations is a distorting population, I think from Councillor Pavlovich. There were significant decisions. These are significant decisions for many residents. So I think the suggestion is that the calling in members and members more generally consider that the HMO policy is a very important policy and it does have an impact on how the city is regulated. So to go into the local plan process to suggest, as Councillor Eyre has made the point, that actually this significant policy that is important to residents is having an impact on communities is not a material policy, is a very difficult position for the planning inspector then to say, well, actually, yes, we can carry on with this, despite the fact that you all believe it's having a significant impact. Now, the inspector wouldn't take into account, oh, well, just want to change it from A to B without an evidence base. So we would then have to effectively work on developing an evidence base that would cause the plan potentially, and again, I would note that it's a matter for the inspector to decide, the plan to either be paused. I think it's highly unlikely it would be paused because of the considerable amount of time it was taken for us to get to where we are. So therefore, there is a risk that the plan would actually, the plan would be sent back. We would have seen to abandon the plan and we would have to start again on the new higher thresholds. So I think there's the other side of that coin is, well, what is the process if we were to continue with the current local plan policy? Well, in terms of the local plan process, the expectation is within the next 18 months, the local plan will be capable of adopting, subject to matters arising in the public inquiries, of which we've got 3 over the next 6 months. But all with a fair wind, within the next 18 months will be adopted. And the question was asked, and I think the suggestion was made, that the reviews only take place after every 5 years. They must take place within 5 years. So actually, it's going to be within 5 years. And because of the time within which the local plan has been in the inquiry process, the expectation of officers and the advice I'm getting on your behalf is that it's highly likely, and I can't say that it will or will not be the case, but it's highly likely that the inspector will ask for an early review of the council's policy. So in that expectation, I do expect it to be in a relatively timely manner. We've also got to consider, from a City of York Council perspective, our local plan will sit within the context of a new North Yorkshire Unitary Authority, which will be looking to harmonise its local plan policies. So therefore, that new local plan policy, as it merges from in the North Yorkshire Unitary Authority, will inevitably require a consideration of the relationship of our local plan with that new emerging local plan. So it would be, should we say, not required, but be timely of the members at that time to consider, well, actually, do we need to undertake a review of York's local plan so that we make sure that we take into account and align with the emerging North Yorkshire local plan? Clearly, it would be a matter for members, but bearing in mind we've got that constraint of it must be reviewed within 5 years. Reviewed doesn't necessarily mean updated. So Councillor Waters is correct. It doesn't necessarily mean that policy H8 would change. It would be just a matter for members at the time to consider whether they chose to change policy H8 or not. There was much debate around the question of data and identification of data. It's true to say that the HMO definition in law is about the occupants, not the nature of the building. And the nature of all our lives is that we move around. And in terms of the occupants of HMOs, their lives tend to be more mobile than the rest of the community, which is partly why they end up in HMOs, particularly in terms of the younger population or those populations that can't afford to effectively settle down. So this is quite a mobile sector part of the population. It's also so true to say, and I think it's been reflected, that many of these properties are owned by landlords, and this is therefore an economic decision being taken by the owners of those properties as to what status that property should have. So at any point in time, a landlord, following the correct procedure associated with tenants' rights, can effectively revert that property back being to their primary residence if they choose to do so, or sell it or put another primary single occupier in there, and that would change the nature of that property. So it's a very fluid situation as to what is a HMO and what isn't a HMO. So the advice base, or shall we say the policy base, the data that is identified within the policy H8 is a reasonable expectation of the gathering of data in order that members can make an informed decision. But as has been highlighted in respect of the planning inspector's review of the policy of the appeal last week, there is his view as, despite the fact that the threshold had been exceeded in the case of the street, not the area, because the area was down at 4%, actually it didn't have a detrimental impact to the community nature of that street, even though it went above 10%. So it's just again worth reflecting that the 10%, whilst it's a clear policy, there is the other considerations. It's not the only consideration that the planning committee would take into account at that particular point in time. And finally, because clearly there'll be many questions, the original intention of the policy, having spoken to planning officers, the original intention of the policy is effectively to create a dispersal effect. So the idea wasn't that HMOs were a bad thing for the city. They provide a valuable source of accommodation to certain sectors of the accommodation. But there was a reflection at the time by members that the over provision of HMO within a community has a detrimental effect on the sense of community. So therefore, the policy, by effectively creating a threshold, encourages dispersal and investment decisions in terms of HMO landlords and over a wider area of the city. And what we've seen through the policy since 2012 is that has occurred in terms of the broader dispersal, but the vast majority of the area that is covered by the Article 4 directive is nowhere near the thresholds covered. If I might, Chair, I just want to pick up on a couple of other things that were in the report in respect of the second part of the resolution, which is the data provision. So the data provision with it that was identified within the report itself also reflected upon an ICO decision. So that's the Information Commissioner's Office decision and the Local Government Ombudsman decision. The ICO decision was in response to a request by Councillor Waters to provide specific information as to student HMOs within the city. The ICO felt and supported officers in the view and members in the view that we shouldn't be divulging effectively characteristics of specific individuals for the purposes of managing a planning policy. But what we are doing, and it's, I think, is reflected in paragraph 28 from recollection, we are looking at publishing the list of HMOs so that clearly the members can continue to observe and effectively reflect on the policy that you've got. The policy is, as described, is a heat map. Sorry, is not a heat map. Is a decision based upon a specific property. So you look at the specific property, you look at its position in the street, and then you also, for the neighbourhood, look at the surrounding ONS areas and consider whether the thresholds have been met. So every time you look at a specific individual property, effectively the policy changes depending on the geographic location of the individual property at consideration. So it's just worthwhile reflecting that, because it took the specific measurements associated with that. And then just finally, the LGO decision. The LGO decision was, in fact, in respect of an error by officers, and it was reflected in the report. Again, I can only apologise on behalf of officers for the lack of information provision for the planning decision that was taken last June. The LGO decision was that it hadn't had a material impact on the outcome on behalf of the applicant and the complainant, but it did recognise that the authority had effectively failed in its bureaucratic processes. And that's partly what the report talks about as to how we've tightened up the flow of information between the local plan team, the planning decision, and the council tax officers, so that we get a constant and more up-to-date information provided to yourselves as members when you're making those planning decisions. So that's just a quick canter through some of the issues that have been discussed this evening.
Okay, thank you very much for that, Neil. I think there's probably quite a lot of information to take in there for people, but I appreciate you trying to cover you know, a wide-ranging discussion that's already taken place. Councillor Norman, I see you, and if anybody else has any questions, I'll just make a note.
Thank you. I've got two questions, if that's all right. The first, a quick one. Councillor Waters mentioned earlier wanting to, as part of a review, talk about Airbnb. I was just wondering if you think that would fall in this part of the framework or elsewhere. And then sort of as a main bit, and do forgive my naivety if it is so, but it seems to me as if this is quite a convoluted, long and complicated process we've gone through to get to this point in the call-in. And it might have been quite simply solved if at some point someone had had a chat with the planning inspector about whether or not this would be considered a serious amendment or not. Is there a reason why we haven't just sort of spoken to them?
Okay, so so the first response is no, Airbnbs doesn't fall under the HMO, so it wouldn't be part of this piece, and to the extent, and that is a piece that Councillor Craghill is asking officers to look at, but there is an entirely different regime, well, or absence of a regime, should we say, in respect of that challenge that the city faces. In respect of having a conversation with the planning inspector, effectively the question would be, from an officer's perspective, we're going to the planning inspector and suggesting that we have got a different view as to what council's position is. So council's position at the moment is the plan that has been submitted is the plan that has been submitted. You have confidence in it. You've resolved that you have confidence in it. It is policy H8. We have a request through the full council resolution that executive consider a different perspective and a requirement to effectively halve the thresholds. If executive wish to progress as required or requested by the full council, then we would have had that conversation as indicated in the option. Members could have taken the view at that point as to whether or not to proceed. So there could have been different resolution as to how to proceed. But the officer's view in respect of the proposal is as proposed by full council, and there was nothing else out there to go to executive with other than what full council had required, which is with a view to halving the acceptable percentage threshold of HMOs. So effectively we go to a planning inspector and say, we haven't got any evidence, but we'd like to halve the thresholds associated with HMOs. And that would be the request that would have been made.
If I can, to be fair to the motion, my understanding is it would have been a review to look at that possibility, at which point in the review, presumably some kind of evidence would have got.
Yeah.
But to get to the point in question, I guess my query is, in order for executives to be fully informed of the decision that they were making, they need all the facts at their disposal quite clearly. And clearly one of the central facts is whether or not the planning inspector would consider this a major bit. And it just strikes me as bizarrely bureaucratic that we can't just sort of talk to each other. Is that impossible?
It is bizarrely bureaucratic, but we are effectively a creature of statute, so we have to follow process. Effectively, officers can't just make it up and go along to inspector and say, what would you think if we did this, or what would you think if we do that? The only proposition that was in front of us was a resolution of full council. The question then for executive is, in respect to the resolution of full council, what did you want to do with it? And they've effectively determined, and you're calling it in, that at this point in time, they don't want to go to the inspector and ask that question, because effectively we'd just be speculating as to, well, we'd like to do something entirely different from what we've submitted. Bearing in mind, full council has resolved and supported that policy. It's not for me or other officers to come up with another idea out of the air and start to go to your regulators and say, what do you think of this?
With respect, Neil, because we're getting into sort of catch-22 territory here, aren't we? There are many circumstances in many different ways where those informal conversations happen that say, this is where we are, this is the current situation, I need to be able to give some advice. What do you think might be the likely outcome of this? And I think that the problem, and possibly what Councillor Norman's getting at here, is that I think earlier on you were suggesting that, you know, it was up to executive members to go and speak to the planning inspector as to whether or not. That certainly seemed to have been given in previous, which I'd noted down as being something a little bit unusual.
Yeah.
So presumably what you're suggesting is that they would need to instruct you to go and ask them, the planning inspector, whether or not this would cause a problem.
Correct.
And your advice was that in asking them, you might create a problem.
Correct. And
so that's catch-22, isn't it?
Well, and let's us suggesting that, or officers suggesting that there might be a problem, is the professional advice of officers who who effectively, this is their job to take things through local plans. But just to give you a sense of the formality of the process you're in, I have never spoken to any of our planning inspectors other than sat in public inquiry. The only way we communicate to them is through the programme officer, and that program on communications with the programme officer generally are published. So effectively, it would start to become a matter of public record that we are asking the planning inspectorate, we're not quite sure about this policy. What would you think if we changed it? We have a plan. We may be requested to review elements of that plan as we go through the planning inspectorate process, and we will respond formally in a context. It's a very formal, and I would agree, bureaucratic process.
Okay. I will come to you in 1 second, Councillor One. Just to finish on that point then, just so we bottomed it out. Are we in a position then at the moment where no policy whatsoever that is contained within the draft local plan at the moment can be considered for any sort of a review at this stage? You would advise that any sort of sense of any tweak to any policy would be inadvisable. Is that
correct? Yes.
Yeah.
Effectively, you've just done your A-levels, you've done all your paper, the stop clock's gone, you've submitted it, you can't go up to the examiner and say, do you mind if I just change the answer that I've given to question 3, please? You go, sorry. You either withdraw your paper and do your A-level again next year, or I'll mark your homework.
Okay. So, and I apologies everybody, Councillor Vassie, I'll just note you down as well. That then begs the question, when that motion first came forward with the question to review the SPD, presumably you would have known that the SPD could not be reviewed unless the policy was changed, and the policy could not be changed without the request being made to the inspector.
Yes.
So why was that advice not given to Councillor Waters at the time, when clearly his motion as written on your advice couldn't proceed?
So his motion wasn't written on my advice. It's entirely the.
No, of course it wasn't written.
No.
Sorry, there's a comma missing there from my.
So it wasn't written on my advice. And I accept your premise in terms of the separation of how it was developed. But in respect of the motions that the members bring forward, it's entirely your free will as to put what motions you want forward. It's not our role to interfere in what you want to put in those motions. They can be totally and utterly out there, and I might fundamentally disagree with them. But as Janie has said, if they meet the threshold of not effectively disrupting your statutory duties to administer the area in a sound manner, which means that you can do it legally and within your financial powers, then it's not for officers to interfere with your.
And I do utterly accept that, although I do think that there has been occasion, certainly when I've been bringing forward a motion, where somebody has said, actually, what you're trying to get at is this, and if you want to get at that, then this is how we would advise you draft your motion. And that has certainly happens.
Yeah, absolutely. And I would encourage every member from across the whole council, if you're thinking of putting a motion to full council, come and have a word with your officers. We will help you draft an effective motion to achieve the outcomes you wish. But what we get is literally at the last minute, you've got, I don't know, what's it, less than 12 hours to consider the motion that's been put forward by X and Y. And then the amendments are really, and then the proposed amendments come thereafter. And again, the time to turn around the effect of those amendments is very little. But my advice to everybody is, if you wish to put a motion that you want to have a specific effect, come talk to the officers about how you might go about achieving the effect you want.
Okay. Councillor One.
Thank you, Chair. It's quite a different question. So we were talking about the real need for an evidence base, and you mentioned the HMO data and information flow was something that was being looked at. Could you say how it's improved over a period of time?
Well, I could say that in respect of the failure that occurred last summer, then effectively that's clearly been brought to the attention of the relevant officers, and that information flow is happening more frequently. I think in respect of the going forward, and it's noted in the paper that the HMO regulatory regime that members may choose to or may not choose to have put into place will have the effect of providing more information. I just need to really stress the point, though, for scrutiny, because this is a matter of public record, that the two regimes are entirely separate. Councillor Musson was very right to note that actually the planning policy regulates the quantity of HMOs. The licensing regime, it regulates the quality. And in terms of the HMO licensing policy, one of the challenges that we've got from the landlords in the city is that we're effectively trying to use HMO licensing to implement planning. We are very, very clearly not. But what happens just naturally as a consequence of a planning policy, and I would note, and it was reflected in the executive report, the specific areas that have been identified by your housing officers for the purposes of HMO regulation are those areas with the highest densities, and they are the areas to which the Article 4 thresholds we are bumping up against them. If I might just extend in terms of the data piece and the improvement, a significant amount of discussion has gone on this evening about enforcement, and I think that is a very relevant point for executive, for members to consider in terms of the quantum of enforcement, but also to consider what enforcement actually means in the local authority context. So the local authority context for enforcement is we effectively have to go implement it through a policy perspective, because enforcement has to be reasonable. So we look to inform individuals, we educate them, and then we enforce. And we may have got to reflect here that enforcement is actually to seek planning permission. It doesn't necessarily mean that those HMOs won't continue to exist, that they won't get planning permission. And indeed, in respect of the planning appeal decision last week, it demonstrates that actually the thresholds themselves are not necessarily arbitrary, because they have to be taken on balance. So when officers are undertaking enforcement activity, you've got to look at the specific property in front of you, the policy that we've got in respect of planning, and the context of where it sits in the city, because as I said, the vast majority of the city isn't impacted by HMO densities getting anywhere near the thresholds that you've set for consideration.
Councillor Norman, I think you had a supplementary. I have got you down still.
Yes, thank you. Just to clarify then, are you saying that in your view, the executive member has misspoke when she said that licensing would impact our planning regime? Because in order to do so, that would break the principle of licensing.
Well, I think it's not that. So let's just be clear. You've got two regulatory regimes that are entirely separate. One is in terms of quantum and one in terms of quality, but they both produce information as to the quantity of HMO. So it would be remiss of us And clearly what we've talked about is the accuracy of decision making. It'd be remiss of us to not take the data that we get from HMO licensing and reflect that, because the final policy, I think the final line in policy H8 talks about where the council knows an HMO exists. So if we were to license it, we would clearly know it existed. So we would take that into account. So whilst they are separate regimes for different purposes, the fact that the HMO licensing policy gives us information that we would be able to take into account planning decisions, it assists in the data side of.
But just to clarify, we are not bringing in a licensing regime in order to collect data for anything to do with planning.
Correct. It's a consequence. We're not doing it for it. It's a consequence. The purpose of licensing is the quality of accommodation and to protect the occupants.
Okay, thank you. Councillor Vassie.
Thank you, Chair. Yeah, first of all, I'd just like to clarify a point you made that should really have been, I think, a supplementary. You were talking about whether we could have a quiet word with inspectors and sound ideas, and you made clear that you can't have quiet words with inspectors. Might it also be fair to say that if we did, actually the City of York Council would probably be considered to have form, since we've changed our mind so many times that even signalling that we wanted to look at something might actually cause chins to plummet among planning inspectors.
So all I would relay is the response that I've already given, which is officers just couldn't make up what we would have a chat with the inspectors about. So you're very right. We would have to make a decision. I would have to be given instruction from officers, from members, and because of my view and my officer's view as to the material impact, that would no doubt be either an executive member or an executive decision. I would have thought executive decision. And therefore, I think it would cause a dropping of the chins as to, well, oh my gosh, the executive has decided to effectively ask the inspectors to review a part of a policy that is a suite. And as I use the analogy for Councillor Crawshaw, we'd like to change the answers to our third question in our A levels. Thank you very much. Do you mind, Mr. Examiner? And I think that they would rightly raise an eyebrow, because we've previously submitted, using my analogy now, I know I'm stretching it a little bit further, but we've previously submitted 5 lots of A-level papers, and we keep going and snatching them back off them before they mark them.
I mean, just to not labour the point, but you know, there is such a thing as diplomacy, and those sorts of conversations in other spheres do take place. And I mean, in our own planning directorate, you know, when you have a major application that comes in, there's all the formal dialogue that goes on, but there is also the informal phone call that says, okay, if I did this, would that be okay? Okay, would that be considered a material change, or would that be considered something that you know we wouldn't need? Does this need a full new application? Those sorts of conversations are routine, I would suggest, in almost all other areas. And I think that the problem, and the reason why I'm picking it up, is that this is being framed in quite a extreme way. And I think that this is perhaps the point that Councillor Pavlovic was making initially on the 2 options. If what we're trying to ascertain is this considered a really minor amendment to a small policy within a whole raft of policies, that question is not necessarily one that's going to cause a catastrophic collapse of a whole process. Now, I take the point that you're saying about saying if you were talking about changes and changes and changes, and you know, we can argue the toss about whether we've made changes and changes and changes. But I think that what slightly worries me about the way that the question and the answer here are being framed is that it is to exaggerate enormously the nature of the question that might initially be asked.
So in response to that, and I don't agree that it's an exaggeration here, it's the advice that effectively professional officers have given to the executive, but just to say that, say the executive were of a mind that that were the case, the recommendation effectively says to the executive, ask the inspectors. We can't answer that question. Only the inspectors can answer that question. Your choice, executive, because this is a member decision. Do you want to ask the question? We're advising it may be classified as a major amendment, might not. The executive effectively have drawn to the conclusion that they don't want to ask that question with considering the timing of the local plan process and the opportunity for review. It's a matter for members. They can choose to do so if they wish.
And I think the nub of this is that I wouldn't want to ask that question if it had been framed in the way that it's been framed, but the question is whether it's been appropriately framed. And gnawing at the back of my mind is the fact that the amendment that was put forward by the executive member and then seconded by a member of the administration, which effectively asked for this outcome and was lost by a single vote, has then been framed in a question or in a report that gives you no choice in executive.
Yeah, and all I would comment is that in respect of the paper that went to executive, the resolution of full council, I am a public servant. You represent the public. You chose to put a resolution to full council that effectively said you wish to halve the current thresholds. Entirely a matter for yourselves. I can only take that and then reflect that to executive. Executive's view was that it would have a, they've chosen to do it. They've reflected that they don't want to ask the question of the inspector because the officer's advice is actually the local plan is, yes, it's over 800 pages, but it's just as fundamental as looking at a 50-page response to an A-level exam and saying, well, I'd just like to amend that one. You've had your opportunity to consider everything in the round. You've done your evidence base. You've submitted it. If you start picking and plucking at it, then the examiner is entitled to take a view. The officer's view was that the examiner would take a view that you shouldn't be doing that. Now, but it didn't say in the executive report, you can't do it. It reflected the power that you have as members to choose the destiny you wish.
I think framing is very fundamental to that decision making, but you know, that's perhaps a moot point. I'm just looking around the room to see if there's any further questions. I'm conscious, Councillor Hook, Councillor Daubney, I don't think I've heard a question from either of you. If you had anything that you wanted to put to officers at all?
Especially since
okay, thank you. Any further questions? If not, I just had one, which I just need to dig out because I had noted it down. Have we covered that? No, to be fair, I think we've covered the questions that I had and largely done them to death. So I will thank you for your time, Neil, this evening. And that moves us then on to the final couple of sections of the meeting today. So there's an opportunity now for members just to discuss amongst themselves if they think that there's anything that they want to clarify in their own minds, or maybe perhaps make any observation or anything around that aspect of anything that we've heard before we then look to whether or not we feel that there's grounds to uphold the call-in or otherwise. So I'm just looking for any indications of anybody who wishes to. Councillor Norman?
Yeah, thank you. If I could just speak about a couple of things. Firstly, I think it's really important that we stress exactly what we're being asked to do now. And it strikes me after that very helpful discussion that one quite clear option would be that the executive takes this back, decides to ask somebody a question, and then decides what to do when it gets a reply to the question. And that to me seems quite sensible. But I will talk about other issues because I think they're really important. And I want to talk about students because we talked a lot about students, and the framing of this kind of debate is quite often, outrageously, a debate of students versus residents. And that is deeply wrong. And I think one of the most important things to take away from these sorts of situations is how bad overconcentrations of HMOs are for students. It leads to overcrowding, it leads to back gardens being stuffed up with huge spaces, to little social space. It leads to dramatic reductions in quality of life for students as residents. And those are really important matters. And our current licensing, our current planning regulation fails in a great many ways students in that sense. I can think of one particular example that we didn't pursue as a matter for planning regulation, because although a number of young women students were living in a residence and a man once arrived at their door, let himself in with a key and informed them he lived in a shed out the back, that was not considered a breach of planning regulation, because it was permitted development to have that many students in that residence at that time. That's the kind of thing that this means for students. It's a bad policy, it doesn't work, and we fundamentally need tighter controls over our streets and policies. And I'm sure we could go into many other examples, but I also want to touch very briefly on somewhere in my wood, Badger Hill. And I think it's really important that we turn to the map here and look at the border of this policy, which will be set in stone for some years if we proceed as we are proceeding now. This policy was formed when Heslington East campus was not built. You will note on the map that it is not there, and the border therefore goes in that direction. There is a field north of Heslington East campus, which is going to be the source of a lot of controversy in coming years as we discuss its role in planning. That field at the moment is outside of the little red line. It is next to one of the largest campuses in the city, where a large number of students reside. And what we would be agreeing to by proceeding with the policy as exists right now is a planning document that essentially frees that land up for housing and does not protect that housing from an over concentration of HMO density, dramatically impacting people in Badger Hill, students in Badger Hill, and students and residents who would live in new developments, as they may or may not get planning permission. It's really important the policy is encompassing as much as possible and protecting everybody, and meaning that our communities are as diverse as possible, because when you live in a street with a good mix of HMOs and non-HMOs, it is a joy to live in them. But when we have an over concentration of overdeveloped massive houses, that causes problems for everybody socially, and it's really important that we tackle it.
Thanks, Councillor Norman. Any other comments from anybody else that they wish to make? I'm just going to make a couple of comments. I think one of the key things at whatever time the review of an SPD into HMOs undertakes is, I think Councillor Norman has made some really important points already, but the impact that a transient nature of housing can have on a street can be enormous. I have somebody in my ward who has lived in the same street for, I think they said it was 1962 or 1963 that they bought their house in their street. And they used to know all of their neighbours, and through a variety of changes, that street has now become a combination of HMOs and private rented houses, but the nature of the street is it's transient. Now that's life, that's part of what happens. But what that has meant is that the people who used to weed the back alley, or the people who used to go out to the shop, or the people that they used to be able to call on when they were a bit infirm or anything like that, that's all gone. And that's what people mean when they talk about their communities being decimated. And I think that it does fall disproportionately on different parts of the city and different wards of the city. And I think it is something that is perhaps difficult to understand for people who live in areas where they have a very fixed community that has been there for a long time and has all those very strong roots of community, to know what the impact is for other areas as they become more and more transient. So I think that that's why there is that sense of frustration and anger. And I do agree completely that it is sometimes misdirected at students, and it's easy to misdirect it at students, because I was a student once and I was probably a bit noisy and not particularly thoughtful of my neighbours at all the times. But that doesn't mean that I didn't need somewhere to live. When we're looking at the thresholds, that 20% threshold and that 10% threshold that were originally largely plucked out of the air, were largely plucked out of the air because that was thought to be a level at which there was some chance of enforcing. That was the way that it was presented to me when I had conversations with relatively senior planning officers about how those figures were arrived at. Now, in practice, on planning, what that means is that you get an application that comes in and you see the street level is 9.8%. You're below the threshold, you are instructed to approve it, and you have to approve it. And that takes it over the threshold, and that's fine. I accept that that's what it does. And in fact, you could have something at over the threshold, and you could take that view that the planning inspector did and say, you know what, actually, on balance, it might just be over the threshold on this particular street, but looking at the wider context, it's okay to go slightly over. And that's the point, it's having that control. By lowering those thresholds, it doesn't necessarily mean that you wouldn't ever have 10% in a street, or that you wouldn't ever have 20% in an area, but it would mean that you would be having a much more focused discussion about whether or not it was appropriate or not for those HMOs to be granted permission. And you would be having that conversation once you got to 3 or 4 or 4.5% in that street, rather than 8, 9, 9.5 in that street. And for streets of 10 or 15 houses or 20 houses, that's a big difference sometimes. So I think that that's why this whole conversation is here and coming about. As to the call in itself, I think the question that we all have to ask ourselves is whether or not we achieve anything at all by sending it back to executive. And I have to say, I have every sympathy with the call-in and the reasons for the call-in, and I am quite clear that the will of full council is not being upheld in this occasion. It's quite clear, it's quite demonstrable to me. Will we achieve anything by sending it back to executive? I'm sort of inclined to agree. I can see Councillor Wan sort of shaking his head in my eye line, and I'm inclined to agree with him. I think the question that then raises is, what's the point in us voting for anything at full council? What is the point? Because if we're going to all put up our hands, and all of us did, if we're going to put up our hands and we're going to say, yes, we support this, this is the way we want things to go, this is what we're publicly saying is our position, and then 3 or 4 months later we go, oh, can't do that. It does really bother me. Councillor Vassy.
Thank you, Chair. I understand a lot of the points you've made. I think if the question is it important to have a serious look at HMOs? I think full council said yes, it is. It is agreed by the executive that it should take place at the right time, supported by an evidence base. So the question really is this the right time? And I think we really seriously have to consider if on the eve of phase 2 of the local plan adoption, after decades of not making it over the line, do we really think that it would be helpful for the city to oblige the executive to pursue a course of action now that might jeopardize the adoption of that local plan that has been decades in the making? And my answer to that is no, I don't think it is worth it. Do I think it's something we need to look at? Absolutely. I think everyone agrees, and the executive have agreed today. It's really a question of timing, so that informs my decision on this occasion.
Councillor Musson, I'll bring you in 1 moment. I just would like us to be clear that the option that was taken by the executive is option 2 at paragraph 38 on page 17. It says nothing at all about a review of SPD on HMO. So there is nothing at all in that decision that was taken that reflects anything of the will of full council, which is what the point of the call-in is.
is this committee not in a position to nonetheless say, if we don't approve it, call in to give a recommendation that the committee is mindful to remind the executive that a review will be necessary at some point, or a form of words that highlight the fact that it is something we'd like to see in the future. And in fact, they have said, they indicated themselves, they would be minded to see in the future.
So two comments. I'm just going to go back to the resolve. So apologies. So I've just read you the option, but the resolve, I've just been corrected on this, is that the consideration of a review of local plan policy H8 and the HMO SPD be deferred until such time as the local plan is adopted. So I will correct myself in that, because that wasn't the option 2 that I read to you was not quite correct in that. The second point that I would make is, if we wish to make any suggestion or recommendation, we do that via the mechanism of upholding the call-in and making the recommendation to executive, because for reasons best known to others, we've been instructed that we aren't to make further recommendations once a vote is taken. Technically, we're still on the old constitution, which might allow us to do so, but I think that the point is the same, really. So if we wish to make any recommendation on anything, we need to vote to uphold the call-in with a recommendation. If we're satisfied that the resolve as it is what it is, then you vote the other way.
To respond, Chair, and thank you for what you've read out there, you have actually indicated that option 2 does indicate the eventual review that I was just mentioning there. So I'm satisfied that it does address the issue that you've raised.
Yeah, I think option 2 didn't, but I think the resolve does.
Yes, sorry, yes, yeah.
Okay, so we move into the very last part of today's business. Oh, I do apologise. I'm so sorry. Thank you for interrupting me. Councillor Musson.
Thank you, Chair. I'm not going to start any big new discussion. I just want to share your frustration at what I feel is going to be something really tough to watch for residents that have been affected by this issue for 10 years or longer, that we speak to on a regular basis, that bear the brunt of this being a lack of political will. Yes, we can say now the reason we're not going to do it is we're on the eve of the local plan. Well, what's been the excuse for the last 10 years when the damage has been done? And what is the further damage that's going to be done while we still haven't acted? And we should have acted on this, 10 years ago. Unfortunately, at the time I was sitting my A-levels, although it was the time that I was accused by Councillor Willison of selling off the toilets. But I would just, like to agree with your point that it is really frustrating, and I do feel a bit of helplessness that I think many residents will feel, particularly in streets such as Sywood Street, where the HMO density is at 80% and shows absolutely no hope of ever returning, because of points like Councillor Waters pointed out, that there is no get out clause for places where this threshold's already been reached. But I would just like to say that one of the points of the original call-in is that the resolves indicates that the SPD and its use is robust and fits the purpose. And I don't think that anyone around this table, this room, or any of the councillors can look a resident of one of the streets where we've passed 20% in the eye and tell them that the use of this SPD has been robust, because it just has not. And for that reason, I'm not satisfied with the wording of that resolution. Even if I do agree that we do need to wait to review the SPD until the local plan, I think the wording was unnecessarily, we're fine. And I think it's a bit of an insult actually to those residents. And I would just like to put that on record.
Thank you, Councillor Musson. I think that if we move then into the final points around the options that are available to us. So page 2 of your report, paragraph 5, there's 2 options, A and B. I think Councillor Norman was suggesting that it might be advisable to refer back to executive and ask that they go and ask the question of the planning inspector as to whether or not It would be catastrophic to make a minor amendment to policy H8 to reflect the will of full council. If we wanted to go down that route, that would require a proposer and a seconder, or if we are sufficiently browbeaten and of the view that it is what it is, then we can propose option B, and I'll leave it to committee members. Well, option A requires a what the recommendation would be, doesn't it?
Well, option A.
Sorry,
Option A
apologies,
is to decide
the
that
wrong
there
way
are no
round.
grounds to make
Option B.
specific recommendations to the executive
apologies,
in
wrong way.
respect of the decisions called in. If this option is chosen, the original decisions taken on the item by the executive will be confirmed and will take effect from the date of calling in, i.e. today. Or you can vote for option B, which is to make specific recommendations to the executive on the decisions called in. The executive has just heard some of your comments. In light of the reason given post-decision calling, if this option is chosen, the matter will be considered at a future meeting of the executive. So you could just do, Chair, a given time, and everybody's had a very long day on this committee. You could vote for option A or vote for option B. You don't necessarily need a proposer and a seconder.
Okay, I was rather wanting somebody to put their money where their mouth was and justify the position that goes against what we've all voted for.
Okay, I'll do it. I'll
Thank
propose
you.
option A.
And a seconder? Thank you. So all those in favour of option A, please show now. Okay, and all those in favour of option B? Or sorry, against option A, I should say, that's what the vote was, wasn't it? Three. So therefore, option A, that is the correct one, isn't it, is carried. It's clearly that time of the evening. So there are no grounds to make specific recommendations to the executive, and the decision that they took stands. And without further ado, I shall close the meeting on that note. Thank you for your time.